The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. Welcome to today's webinar. My name is Barbara Scafidio, and I'm the editor of Prevue. I'll be your moderator for this virtual event with attorney John Foster of Foster, Jensen and Gully, specializing in the legal aspects of meetings and conventions, trade shows and events, and association management. We're going to chat with John in just a second, but first, a couple of brief housekeeping items. During the presentation, please feel free to enter your questions in the question box. We'll gather them together and hold a Q&A at the end. We anticipate we're going to be able to spend about 15 minutes on Q&A, and that John will be able to answer the questions we don't get to offline. There's also a PDF of the presentation in your panel, which you can feel free to download and take notes right on there. Qualified attendees, as with all Prevue webinars, will receive one CEU from the Events Industry Council. And don't worry if you're pulled away from your computer. The event is being recorded and you'll receive a link afterwards. Finally, many thanks to today's special sponsor, the Greater Miami Convention and Visitors Bureau. Okay, John, I'm going to give it to you to take it away.
Great. Thank you, Barbara, for the introduction, and good afternoon to all of you. I'm going to put my PowerPoints up so they're front and center. Thanks for joining us this afternoon for coronavirus in your meeting contracts. Without a doubt, as the description says, coronavirus and meetings is the #1 topic in the industry right now. And if your meeting is scheduled to take place in the next few months, you're trying to figure out if your contract covers force majeure, when does force majeure apply, and more importantly, what should your contract say going forward, either if you're renegotiating or doing new contracts for the future. I'm going to give you all that. Let me also go with our next says, I have to give you a disclaimer since I am an attorney that I'm not acting as your lawyer today, that this is a educational content, and that if you want specific legal advice, you should approach an attorney, engage the services of an attorney of your choice, whether it's me or somebody else that's knowledgeable about your specific issues and your specific problem. So now we got that out of the way, we'll keep moving. I want to go ahead and put my contact information on the screen first and foremost, so that if you got questions for me after this that I don't get to, or you want to follow up for some reason, there it is. And this is in the handout material, so I'm getting ready to get off of that, but you can get it from the handouts. Here's what I'm going to talk about. I'm going to talk about what's going on in our industry and our country, options when faced with cancellation versus termination, go or no go. Is coronavirus a force majeure? What are the triggers? Different views of force majeure to hotels versus meeting sponsors, and why force majeure clause seems to be contentious in negotiating it. We're going to talk about the legal principles behind force majeure. If you understand those, a lot of this will make a lot more sense, and how the terms are always strictly construed. We're going to talk about analysis of the terms and some tips for preparing future clauses, and then the role of insurance. Now, there's a lot to this, and so I'm going to talk kind of fast for a boy from Georgia, so you're going to have to listen fast. But like Barbara said, I am going to try to cover some questions at the end. And then the ones I don't get to, try to address either in emails, or Barbara and I are talking about doing a follow-up article for her publication and address some of the questions. All right. Coronavirus is not the first time force majeure has been front and center in the industry. I've got on the screen just some things that the industry's been dealt with and that we've learned from the events of 9/11, 2001, when we had terrorist attacks, through a fear of flying lawsuit, volcanic ash in Europe, the SARS epidemic, and the bird flu in 2003. Then we had Hurricane Katrina. We had strikes by hotel employees, Legionnaire's disease instance where a hotel closed last year in 2019. And then we've had other diseases that have come up, Ebola, Zika, and now coronavirus. So the force majeure clause continues to be important, not just now, but it's been important for a long time and will continue to be so as the industry and the world becomes more complicated. What's going on in our country? If you're a planner, and you're keeping up with the news, this is what you're seeing every day. You're seeing 115,000 plus deaths from coronavirus. You're hearing about over 2 million coronavirus cases in the United States, and these were as of a few days ago. They're a little higher. You're hearing about recent headlines from the CDC is that cases jump in 21 states. Most meetings and events have been canceled and postponed for the next few months. But then you're starting to see headlines like the one on the right in my local newspaper. This is from a few days ago. States lift more virus restrictions. So we're getting a lot of mixed messages. Is it safe to go or no go? And you're going to have to go through an analysis on that we'll talk about. And then another headline: health officials fear second wave amid reopenings and protests. So we're getting it on all sides. The states are lifting they're lifting their restrictions and are encouraging people to go out. And then on the other hand, we're hearing about potential second wave coming up in the fall. The increased cases I'm hearing about right now, the health experts are telling us that this isn't second wave right now, that this is a continuation of the first wave. So however you catch it or whatever you want to call it, it's a concern for planners. Planners have a duty not to subject their attendees to unreasonable risks of harm, and their organizations to take care of them financially. Hotels have an obligation to take care of their financial aspects as well. So this is what we're balancing out. So these are the headlines we're seeing every day. The CDC issued new guidelines just on June 1st concerning gatherings. I'm not going to go through all those. And I'll point out that these are guidelines and not regulations. The CDC does not issue regulations that are binding on anyone. They don't issue laws, they don't make laws, but they do issue guidelines that are very heavily relied upon and will be relied upon when it comes down to evaluating whether planners mitigated certain risks and so forth. Individual states and cities have issued their own guidelines and regulations. And most of the regulations that we're seeing from the cities and states actually are laws. They actually are regulations and not merely guidelines or advisories. And whether or not your contract incorporates just regulations or if it also talks about advisories is going to have a big difference on your reaction to it and your success at reacting to it. And then airlines are starting to increase travel loads. So people want to travel. People want to get out there. We're seeing more people in the airports. We're seeing more, more passenger load. But at the same time, surveys are showing people are still fearful of traveling. CDC has still put out warnings for individuals that are in the increased risk category, meaning the over age 60 and or individuals that have underlying health issues, and that encompasses a lot of people. All right, so what are your choices? You're sitting there saying, okay, I'm seeing all these headlines, I'm seeing all these things going on. What are my choices when faced with a cancellation versus a termination decision? First choice is to move forward with the event with fewer attendees. And the second would be to postpone or reschedule the event or consider virtual options. So move forward with the event, knowing that you're going to have a smaller number of attendees, or postpone and reschedule the event. Most of the planners I'm representing are postponing and rescheduling. Either, if they were supposed to meet in the spring, they're moving it to the fall. Some of them are moving it into 2021. The third option is to cancel the event and pay cancellation damages. That's the least popular of the options, but it is an option. It is on the table if the other situations don't apply. Or cancel the event and terminate the contract and claim a force majeure. In other words, you cancel the event, but you terminate the contract, and but you only want to take this option. The facts support that you have a valid force majeure claim, and not every situation is going to incorporate that, but that is one of the options. And finally, wait till closer to the event to decide. I got a call last week from a group that has their event booked in March 2021, and they're nervous about showing up, and they're wondering whether they should cancel or postpone it. And I'm telling them it's way too early to decide that, because the fact, you've got to base the facts on when a decision has to be made, and you need to wait until as close to the event as possible before you make the decision whether you're going to move forward and have the event with less attendees, or whether you're going to postpone and reschedule it, or whether you're going to cancel and have to pay damages, or cancel and terminate the contract and argue a force majeure or wait closure. And my advice to planners has been wait until perhaps 60 days, 90 days at the outset before you have a realistic idea of what's going to go on in that area. The CDC has certain guidelines on steps to consider if you're making a go or no go decision based on health issues. You know, what's the community spread going on in the location where the venue is? What's the rate of the cases and so forth going on in the cities or locations from where your attendees will be coming? You know, what's going to be the financial impact if you show up, and are you able to have an event with a lesser number of people? Some groups can and anticipate that they're going to have lower attendance anyway, but some groups say no, we're anticipating 200 people. We need 200 people. That's all there is to it. And if their facts support that, then that's the fact. But these are your basic 5 options right there. And more people are going to virtual meetings, which means smaller number of meetings on the ground or in person, or means no meetings on the ground. But then they still have to deal with the contractual issues and consider the other options. All right, I want to explain now, talk about terminating the contract and canceling the meeting. There's a legal difference between termination and cancellation. And I hear a lot of people use those terms interchangeably, but they're not interchangeable. Every contract's got a cancellation clause. Most every contract has a termination clause, although it's sometimes called the impossibility clause or the force majeure clause. I call it something else, which I'll get to in a minute. Cancellation means that one party decides not to perform its obligations under the contract for reasons other than a force majeure event, and the canceling party may owe damages. So if you tell the hotel you're canceling, then they're going to go to the cancellation clause and look and see what you owe them. Termination means that contracts be terminated if the performance becomes, we're going to talk about these terms some more, illegal or impossible, commercially impracticable, or the purpose of the parties is frustrated. We're going to talk about the triggering terms in just a minute, but if a contract is terminated, it means both sides go back to zero and neither side has any obligation to the other. That, I guess, is as close to win-win that you can get in a bad situation, is that both sides go back to zero and cover their own losses if they are any. But just realize that you cancel a meeting. If you have a force majeure, you're canceling the meeting, but you're terminating the contract. And those two terms are extremely important in communication and how you're using it. All right, now we're going to talk about how to distinguish whether something's a force majeure or not. Again, I've seen the impossibility clause, act of God clause, the pandemic clause, whatever the case may be. So let's take a look at what all those terms mean and what they should be. First of all, what is the purpose of the force majeure clause? It allows parties to allocate the risk and decide in advance what will or will not excuse performance. And that's what the force majeure clause is all about, is whether one or both parties' performance is going to be excused. The party that's affected by the force majeure event, as a matter of law, can be excused from performance. Second is, when applicable, it's a complete defense to performing the contract. If there's a force majeure event triggered under the terms of the contract, then that's a perfect defense to performing the contract. The act or occurrence obviously has to be outside the control of the party claiming the defense. And it must fit one of the standards for excuse, which we're going to get to in just a minute. There's one bullet point that I neglected to put up here, is that normally force majeure covers force majeures triggered for events that are unforeseeable and not contemplated prior to the contract entering into. The tricky part about that is, now that we know that pandemics exist that affect meetings and travel, we know that terrorist attacks affect travel, we know that hazardous weather after Hurricane Katrina can shut down a city and affect travel. and on and on and on. And now that these events are known, they're no longer unforeseeable, and they need to be contemplated in the contract, or the parties run the risk of waiving the right to complain about it later. I'll leave that there, and if you've got questions about it, you can ask me. All right, why is force majeure clauses so contentious to negotiate? Well, the reason is because it means different things to the different parties. What it means to a hotel is it's totally impossible for the meeting to be held or for the hotel to provide its facilities or services. In some cases, I see one-sided force majeure clauses that just say it's a force majeure only if it's impossible for the hotel or the convention center or other venue to provide the facilities. They at least need to be made reciprocal. But in this case, force majeure is only based on impossibility, and that's a pretty high standard to meet. But what it means to a meeting sponsor is entirely different. Force majeure is any act or event that occurs after the contract's been signed that materially affects the meeting and makes it substantially more difficult to stage the meeting as planned or attract the number of attendees as planned. In other words, I'll give you an example of when that affected. In 2003, my partners and I represented an organization, American Association for Cancer Research. This was in the newspaper, so I'm not giving anything away. In Toronto, when the SARS epidemic hit, and the board of directors was meeting in Toronto a few days before the meeting was supposed to start, and they were reading in the paper every day about the number of cases that were reported the day before, number of people in the hospital, and number of people that died, much like we're reporting now. And the unique thing about that meeting is that their attendees were all doctors, and they all work in hospitals, and they began to get massive cancellations from their attendees who said they were supposed to have 18,000 doctors attend, and they were getting massive cancellations because their doctors were told, if you go to Toronto during the SARS epidemic, you're going to have to stay in quarantine when you get home, and you're not going to be able to see your patients or come in the hospital. Well, that was unacceptable to these doctors, and they got down to the point where, again, there weren't enough attendees that were willing to show up that made the meeting worthwhile. So the group canceled their meeting, got out of town. They were able to move it to another city at a few months later. But the city of, they actually had contracts with 18 hotels in the convention center. And I got to emphasize, the city of Toronto didn't do anything wrong. The hotels didn't do anything wrong. I got a lot of good friends in Toronto. It's a great city. So if anybody here from Toronto is listening, I'm not down on them. It was a bad situation for the city of Toronto. They were sent a bill through the Convention Visitors Bureau for $6.5 million, claiming you canceled, you should have shown up. And we defended on the basis that, you know, when we booked this meeting, there wasn't a deadly disease going on and people weren't dropping dead. And we don't think we have a duty to show up, given the fact that your city is ground zero, and so forth and so on, some other facts. The case was mediated and settled out of court, and that's the good news. But we learned that epidemics and diseases are indeed a force majeure event because they affect travel and affect whether attendees want to show up. So that's a whole, but it wasn't impossible to have a meeting. I guess that's the point I'm making, is that fell under the impracticability, a frustration of purpose and impracticability, but it wasn't impossible. But again, this was mediated and settled out of court. Let's keep moving on. There are actually 5 elements of a force majeure clause. As I'm reading it, this is what I'm looking for. I'm looking for the list of the supervening events that are in the contract. In other words, the supervening events would be where you name the acts of God, you know, strikes, terrorism, civil unrest. And if you reference epidemics or pandemics or communicable disease, you need to make reference to the CDC or the WHO, the World Health Organization, or Department of Homeland Security as a reference point. Need to make sure that they reference that it's a pandemic or epidemic. And you don't want to name the disease. You don't need to put coronavirus or COVID-19 in your contracts, because the next disease that comes along, obviously it's going to have a different name. We've had Zika, we've had Ebola, we've had SARS. Now we have coronavirus. Who knows what the next one's going to be called? And there will be a next one. It's just inevitable. That's the way it goes. If you're going to reference a disruption in the travel, you need to put a percentage in there, which said that if 30% or more of the people can't attend because of one of these supervening events, then your performance obligations need to be reduced by the same percentage. In other words, attrition and catering events. But you're responsible for showing up with the number of people that you can show up. There needs to also be a trigger point, say that if the number of attendees affected by the supervening event reach a certain percent, whatever you agree to, that's negotiable, and whatever that percent is that makes to the planner that makes the meeting tenable, that could be 40%, could be 50%. That needs to be stated in there. Next thing you need to make sure is that you have a catch-all phrase. You can't name every bad thing, every disaster that has happened in the world. So I usually put in there, including but not limited to, or the words, or any other act or occurrence beyond the party's control. So you need to make sure that the list you put in there, it's not the definitive list, and it only the bad things that only the supervening events that are named in there are the only bad things that you're going to recognize as a force majeure. And then you need this is probably the most important, the list of standards for the excuse to apply. In other words, is it going to be illegal, just illegal if it becomes illegal, or impossible? And right now, most hotel contracts that I see, before I get a chance to review them anyway, say illegal or impossible. And that's a very strict standard. I recommend adding the other standards that we're going to talk about in a minute, like commercial practicability and frustration or purpose. And we're going to talk more about those coming up. So you want to list the standard for the excuse to apply, because you can have all the pandemics in the world, you can have all the supervening events in the world, but they have to trigger the standards for excuse. And repeat those again: illegal or impossible, commercially impracticable, or frustration or purpose. And then you need an operative phrase in there that says that the party so affected may be excused from performance. In other words, you got all these bad things happening, so what? Well, you need to put in there what the so what is, that the party so affected can suspend or terminate performance. Force majeure clauses also have notification requirements, which is the timing and the method for notification. In other words, the party affected needs to notify the other party that they were going to invoke the force majeure clause, excuse me, within a certain number of days. Don't limit it and make it a short period of time. I'm going to talk about one lawsuit that said, like 5 days coming up in the next slide. And if there's a disaster going on, you may not make a decision 5 days. So I usually say it'll be within a certain number of days, or within a reasonable time, or a certain number of days after the decision's been made, because you may have to do a lot of due diligence before a decision's made, and that a requirement that the notification has to be in writing. So a well-written force majeure clause will have these 5 elements to it, and each one of them is important. All right. With a well-written force majeure clause will have the things I just discussed, but for the force majeure doctrine is built into contract law anyway. And if there's no force majeure clause, and there's none, there's no impossibility clause or active God clause or whatever, the law still provides the following items. If performance is impossible or illegal, and you see the word objectively there, that means it's not only impossible or illegal for that group, but it would be for any other group. It can't just be subjectively impossible. It has to be objectively impossible. And that's on a case-by-case basis, obviously. The second standard would be the fundamental purpose of one of the parties has been frustrated because of new events. And I'm going to talk about frustration coming up in a few more slides before we cover that, but they just realize that's one of the principles. In the last but not least, performance is not impossible, but it's been made impracticable. Notice the word is not impractical or not inadvisable. Impractical and inadvisable, I see in terms, but there's no legal definition of what those terms mean. You can use them if you want to, but you're going to create a lot more chaos in disputes than if you just stick to the terms I'm giving you. Impracticable does have a legal definition according to the restatement of contracts, and any attorney can look that up for you. What does that mean? Impracticable means substantially more burdensome than originally expected due to an extreme or unforeseeable event occurring that the parties could not have reasonably anticipated, i.e. foreseen. Foreseeability is a big issue in force majeure. Impracticable, I think the situation I just discussed about the SARS epidemic in Toronto is a perfect example of impracticable. It was not impossible to perform, but it didn't make sense to perform if so many people were getting sick and dying. And if that's going on in certain cities here in the United States, that's something that needs to be tracked and is going to be a factor in your negotiating. All right. Typically today we're seeing, what's known as a typical impossibility clause, which says no damages will be due or failure of performance by either party occurring due to acts of God, war, government regulation, riots, disaster, strikes, any one of which make performance impossible. The party so affected must notify the other party within 3 days of the act or occurrence. This was a clause used that was subject to a lawsuit in federal court. 2006 called National Association of Postal Unions versus I Regency Washington. The whole issue in that case is that they had grounds come up for their claim that the contract force majeure kicked in, but they waited more than 3 days before they notified the hotel. And the hotel says, sorry, but your 3 days ended last week. Therefore, that's our defense. We're not accepting your claim of force majeure. And the group lost the case because they didn't meet the 3-day requirement. And I submit to you, 3 days is not a very long time if you've got issues going on. And as I stated before, make it a longer period of time, or just say within a commercially reasonable time, or within 3 days of making a decision, as opposed to 3 days of the act or occurrence. Because here with coronavirus, where does 3 days start? Even if it said 10 days, when does the 10 days start? Does it start back in January when the World Health Organization declared coronavirus a pandemic? I don't know. I don't know how that works. But anyway, this clause I would reject if it came across my desk today, because it only limits, again, performance to impossibility. Here's other tips for preparing your force majeure clause in the future. And notice I actually call this, I put this in quotes at the top, I actually call it a force majeure / excuse of performance / termination of contract clause, because it's more than just force majeure events. It's any other act or occurrence that would excuse performance and allow termination of the contract by one party or the other. So to call it an excuse of performance and termination of the contract clause is more accurate. Some things you need to understand: that number one, force majeure clauses are strictly construed. In other words, you do need to have, list the things that you consider supervening events, and have the catch-all phrase that says including but not limited to, or any other events similar to this that cause impossibility, impracticability, frustration, or purpose. But they are strictly construed. And so this is why every time something bad happens in the world or bad happens in our industry, attorneys like me go back and add that to the clause, because the force majeure clause needs to be current. It needs to represent real world events. And impossibility is not, limiting it to just impossibility or illegality is not real world, in my opinion. And you need to depend on the legal standards included. And I'm getting ready to cover examples of that coming up. If your contract says illegal or impossible, the only thing that's going to trigger that would be an airline strike where nobody can get there, or the hotel or other venue burns down. Or illegality would be if the governor, like most states have put out guidelines that follow the White House guidelines, phase 1, phase 2, phase 3. Right now, most of the states are either in 0 or phase 1. They're hoping to go to phase 2 in the next 30, 60 days, but that depends on the number of cases that are out there. I've got groups that are meeting in a certain state in the fall, and they're looking at what the guidelines hopefully will be in phase 3 by then, which means the number of cases will be down enough to where they can open up some of the restrictions a little more. Again, each state's different depending on their cases, and the guidelines in each state is different. So there's no one standard that fits all. I've got, on speed dial, or actually on my computer, the download page for every one of the major cities that my clients are holding meetings in around the country to keep up with new proclamations or new executive orders that come out of the governor's office, because those are legal guidelines and regulations. They're not just advisory. So you need to keep up with that. And if you remember, back in April and May, I think it was Louisiana had so many cases that they banned all mass meetings over a certain number. I can't remember if it was 50 or maybe it was 250, not sure what. But I had several groups that were scheduled to go to New Orleans during that time, and it wasn't even a conversation anymore. The governor had already shut down all of that. But even if you're talking about your meeting in a few months or in the fall, you still the locations in phase 3. Phase 3 still has social distancing guidelines and still has warnings for people that are in the suspect category, meaning over 60 or underlying health conditions. And so that's going to factor into it too. Commercial and practicability, that's a little bit wider, as well as frustration of purpose. Commercial and practicability, the situations where in frustration purpose I'm going to talk about, you need to have your frustration purpose. I recommend having a purpose of the meetings clause. We'll talk more about that coming up, but that's something that should be included so that you can point to it if it applies. All right, understand this too, that the doctrine of impossibility, frustration of purpose, and impracticability apply only where the parties themselves didn't allocate the risk of events that have rendered performance impossible, impracticable, or frustrated. In other words, you can write your clause to say whatever the parties agree to. You can write your clause to include more than just acts of God and so forth. And I recommend that you do that. That you have certain things that you deal with. I want to back up on something I neglected to mention. Go back to the slide here. Is that, again, so commercial impracticability, I want to talk about that some more, means more difficult to form an agreement by one or both sides due to circumstances that occur after the contract that weren't reasonably foreseeable. And a pandemic, I think, falls into that category. Frustration purpose, I think, applies if the purpose of your meeting is to have face-to-face contact and so forth. You need to discuss with your hotel whether they can follow the CDC health guidelines about spacing, and whether or not they can accommodate the number of people your group anticipates and still adhere to the health guidelines. And I'm not going to go through all those health guidelines, but you need to download the CDC guidelines as well as the World Health Organization guidelines and get an update on that. Frustration of purpose also applies. I'll give you another example. Say you're having, you book a resort, books a resort that has a golf course, and they did it for the purpose in the contract stage, for the purpose of having a golf tournament or a client event or a team building event on the golf course, using golf. And suppose a week or two before the event, a hurricane comes through and damages the golf course so that it can't be used. Well, that's a frustration of purpose. So the group is able to get out of that contract because their purpose of meeting there for purposes of having a golf event just got eliminated through no fault of their own, through no fault of the resort either. So that's a perfect example where frustration of purpose would kick in. If the resort decided to rent the golf course out to somebody else or use it for some other purpose, that would be a breach of contract for the resort. And that's a different situation. Frustration of purposes would apply as if it happened that neither party had control over it. Another example would be if you book a function and the purpose is to have a specific well-known speaker to come and talk to your group, and that's the purpose of the meeting. And if that speaker gets sick or cancels out on you through no fault of the group, then that's a frustration of purpose, as long as your purpose was specified in your contract. A frustration of purpose clause, I usually, when I came up with this several years ago, I usually put in there the anticipated number of attendees within a certain industry, and from a specified geographic area. That may be the entire United States. It could be the United States and Canada. It could be the United States and Europe. If you expect them from these other countries and so forth, your purposes clause ought to explain that. There have been lawsuits about that too. If you have a high percentage of people that are in the vulnerable category, that are over 60, or that of medical issues, that needs to be in the purposes clause, so that if something changes that affects that, you've got a claim to talk frustration of purpose. This is a good point. Talk about written letters of adequate assurances. If you're not sure if your hotel is going to be able to meet your purposes, and I'm talking about CDC health guidelines on social distancing and anything else they come up with. Contract law says each party has a right to demand written assurances from the other party that they're going to be able to perform. And I've written a number of these letters in the last 30, 60 days about asking hotels if they're going to be able to meet guidelines that have been established in the industry or established by the CDC. And if they can't comply, if they can't answer in the affirmative, or if they refuse to answer, that's considered under contract law to be an anticipatory breach, and they could be held liable for, again, anticipatory breach of the contract. And so that's a tool that's out there. Hotels need to understand it, and their lawyers do, and planners need to understand it. All right, move on a little bit. What I'm trying to mention there is that you can write your clause to say whatever is negotiable, whatever's important to you. And I'm going to give you some tips on what should go in there. Number one is that clauses should be broader than just acts of God. We're talking about more than just hurricanes or bad weather or earthquakes or whatever. We're talking about a whole lot more situation than that. They can include contingencies that must occur or not occur that are significant to either party's performance of the contract. And I've talked about attendance from certain states or certain speakers or other categories of things that are going to be important to you. All right. The parties must specify the impossibility standard needed to invoke the force majeure clause, in addition to illegality, which takes care of itself, or commercial impracticability, which is not well defined, or frustration purpose, which is not always defined. But if you do include impossibility, and it should, you need to decide whether it's got to be total impossibility or temporary or partial impossibility, as well as inability. I always include and provide for partial impossibility. And what that means is, since you've got attendees that are traveling to a destination from all over the United States, say you've got a meeting in January and your meeting's in Florida. And in Florida, it's nice and sunshiny, but you have a substantial number of people traveling through O'Hare Airport in Chicago in January when they have snowstorms up there. And sometimes the airport gets shut down for 2 or 3 days. Yet the destination is nice and sunshine. So you need to provide for the fact that if a force majeure takes place somewhere else that affects attendance there, that your performance obligations need to be reduced. So if 25% of the people can't get there because they're coming through a closed airport, then your performance obligations in both rooms and catering ought to be reduced by the same percentage. All right, let's keep moving. Obviously, it ought to include acts of God. Hazardous weather, I usually put actual or forecasted. War, I usually include declared or undeclared, or specific threat of war. Construction and or renovation facility. And I'm just going through these sort of fast. Government regulations, advisories, guidelines. So I include more than just regulations that say thou shalt not go. Advisories, the CDC puts out very important advisories. that have to do with health and safety. And again, the CDC does not make law or doesn't issue regulations, but their advisories are taken very seriously and their guidelines are taken very seriously. And a lot of times quarantines can be either regulations or they can be advisories by city and state. So I think you need to encompass, if you're a planner, you need to encompass all the above. If it's an overseas meeting, you want to reference government regulations by the United States or the foreign country where you're located, or I'm sorry, where your meeting is going to be located, that restricts travel, including, advisories, quarantines, or curfew, because each country has been reacting to this coronavirus and has their own guidelines that are out there. Strikes, labor disputes, picketing, work stoppages, actual or threatened material effect in the meeting. If this is important to you, change in hotel ownership or management company, deterioration of the facility from the date your contract is booked, an epidemic or disease in the city or region, what we've been talking about, where the meetings be held, or from where potential attendees would be traveling. And since we can't think of everything that affects health, I usually add a clause that say any act or occurrence creating a significant risk to the health or safety of potential attendees. And loss of health, that should be health permits at the facility, not heath, should be health. All right, damage or harm to the city or region, materially affecting basic governmental services or functions, or to the city's reputation where the meetings to be held. I came up with this after Hurricane Katrina, sort of altered things in New Orleans for a few months afterwards. That became very important. Damage to the reputation of the facility of the city or region, materially affecting the meeting sponsor's ability to attract attendees. This would again fall under the purpose of the meeting clause as well. What do I mean by this? Unfortunately, again, after Hurricane Katrina, and I'm not picking on the city of New Orleans, it's one of my favorite cities. They were caught in an unfortunate situation after a hurricane. But there were a lot of negative images on television, whether they were accurate or not, they were there. And they affected meeting sponsors' ability of people to show up. And I wrote an article about this, and mainly I said you need to poll your stakeholders. You need to poll your potential attendees, your exhibitors, and your sponsors to see if they're still are they going to support you? Are they going to show up? Or are they just telling you they don't want to come? And most of the groups I had, some of the groups, I say most groups I had, the attendees said, we're not showing up in this city in the next 6 months. Now that was, a long time ago and it's past, but it didn't make sense for the groups to move forward. So you got to make a business decision first, is what I'm leading up. Before you get into the force majeure, find out whether the situation on the ground is going to affect your attendees. I had some groups who said, yeah, we'll support the city, we'll show up, we'll be no matter what. But the meeting sponsors didn't know this until they actually did a poll of their attendees. I've got groups that are doing that now. They're polling their attendees about going to certain cities in the next 2 or 3 months, and they're going to make their decision based on what their attendees give back to them. Are there new law? If you want to reference new laws, if you perceive civil rights laws that your group is going to object to, you need to reference that in your force majeure clause too. Acts of terrorist or specific threats. I think threats ought to be valid to react to. In other words, if the Ayatollah says they're going to be sending Scud missiles to your meeting venue over the dates that you're going to meet there, I can guarantee if that's in the news that your attendees aren't going to want to show up to find out if it's a bluff or not. So you want to be able to react to specific threats. Cancellation or restriction of commercial travel to or from the meeting location, that's self-explanatory. And use of the convention center. If you've got multiple properties and you've got properties and convention center, those contracts need to be tied together, that if one of them falls out of the loop, that you don't have the obligation to use the other ones. All right. Again, same thing with multiple hotels. I'm going sort of fast over this. Let's talk about insurance for a second. Convention cancellation insurance is something I'm a big fan of. I recommend it, particularly if you've got a lot of, if you've got a high revenue that your organization depends on the net revenue of your meeting. Like most associations, their annual meeting, they depend on the net revenue of that meeting. And if the meeting gets canceled, they're in a world of hurt. You can get convention cancellation insurance that covers certain perils and so forth, unless they're excluded. And if you've ever studied much about insurance contracts, it has 3 or 4 pages of what it covers, and then it has 20 pages of what is excluded. And always read the exclusions first because they're the most important. If what your problem's excluded, then that you know whether you're going to get coverage or not. This was the case that came up in the SARS epidemic in Toronto in 2003. Back then, that's the first time a pandemic had affected worldwide travel. And the insurance company we were dealing with initially canceled or denied the claim, even though they paid a $40,000 premium. They denied the claim until my partners and I got involved, and we threatened to sue them and so forth. And they came around and said, okay, we realize this ought to be covered. And I almost fell out of my chair when they gave me that phone call. But we pointed out the reason that they should cover it is that it was excluded, and they agreed to that. Well, obviously, after that claim came up, they excluded all epidemics and diseases or communicable diseases. And they've been excluded primarily since 2003. Now, you were able, if you were smart enough and concerned about it, you were able to get that exclusion removed by paying an extra premium. Some groups did that. Some of my clients did that. But that exclusion, the right to pay for it, went away in January of 2020. Once coronavirus became in the headlines and you couldn't get insurance for it. The old joke is insurance companies will sell you an umbrella, but only if the sun's shining. If it's raining, they're not going to sell you an umbrella because it'd be too expensive and they don't know how to rate it. So insurance, insurance is a good thing to have because it covers a lot more than just coronavirus. And you need to do a risk-benefit analysis. But coronavirus, you won't be able to get insurance for it for probably another year or two until it dies down and pretty much goes away, or we get a vaccine. The insurance companies aren't going to touch it with a 10-foot pole. That doesn't mean you shouldn't get convention cancellation insurance. Because like I said, it becomes very important in protecting other areas. Also, it's that fear alone is not grounds for a valid claim. The claim has to be backed up by a government regulation or government action on it. Just to say our attendees are afraid to go to a certain city because of a virus isn't going to trigger a claim. There has to be some other governmental action or guideline that triggers a claim. But that's all I'm going to say about insurance. Here's sort of a 4-step process to determine your go or no go decision. Review your contract. What triggers are required? Is it illegal? Is it impossible? Is it impracticable or frustration of purpose? And note the time frame to notify. Research your federal, state, city, and county government guidelines for regulations and advisories in the destination where you're going to, and keep up with CDC guidelines and World Health Organization guidelines and White House guidelines. But the ones that have the most teeth in it are the state, city, or county guidelines. If you have insurance, review the terms and what the exclusions are and see what your policy says about communicable diseases. And then, as I mentioned before, poll your attendees and your stakeholders, exhibitors and sponsors and so forth, to see if they're going to support your decision to show up. If they're going to show up, fine, you don't have a problem. If they're not going to show up, then you got to make a business decision and go back to the 5 options I mentioned. Your option is to show up with a smaller number of people, or to postpone and reschedule, or cancel outright and pay damages, or again, wait a little closer to see if the facts changed. That's the end. I'm going to come back to Barbara and see what questions we have. Barbara, I'll let you monitor those, and I'll wait.
Okay, can you hear me? I'm going to get that webcam on.
I can hear you. Can you
now
hear me?
You can see me.
Okay, I see my scary face up there too, but I hope and assume we have some questions there.
Oh, they have been pouring in, John. So I'm going to start with one that struck me as surprising. When a hotel refuses to include impracticable in the clause, just outright refuses, what do you do?
Well, you got 2 choices. One is continue negotiating. Actually, 3 choices. One is to continue negotiating. I explained people on the other side that this is an allocation of risk, and this is what, and that your organization isn't willing to accept the risk of what's going on right now coming up again. And yeah, a planner today, I recommend, would be a fool to sign a contract that doesn't include all the legal standards we just mentioned. I mean, because we know that we know this thing's going to come up again. We know it's not going to go away, and it's a matter of who's going to accept the risk of that. So if you can't negotiate, there's the law of 2 feet, which means use your 2 feet to go down the street to a different hotel and see if they're a little more reasonable. I call that the law of 2 feet.
Yeah.
The third thing is to just not have any force majeure clause in there. When negotiating with the other side gets real sticky on what terms are going to be in there, not in there, I just say, fine, we won't have a force majeure clause on there because the law has it built in for you to make those arguments. If they're not in the contract, they're still available to you legally. So if we can't agree to it, fine. If we can't agree to it now, we just have to argue about it later, and we'll see what happens.
Okay, I like the law of 2 feet.
Yeah.
Here's something on a whole different level that we really haven't talked about, but I think everybody's thinking about. Should we require our attendees to sign a waiver when they register for our meeting?
There's a lot of disagreement about that. A waiver, there's a matter of tort law. I'm actually doing a presentation on this day after tomorrow with a little more detail in it. But I'm advising people to do a waiver. Yeah, I am. And you can put it in your registration materials. You want to give them the opportunity to agree or disagree with it before they get to the registration desk. You don't want to be turning people away at the registration desk unless they're sick. That's a different topic. So you want to have that discussion before they get there. And if somebody doesn't want to sign it, then that's fine, but they don't get the right to show up either. And basically, there's a concept in negligence law that says if a person knows what the risk is and they assume that risk and take the action anyway, then they can't blame somebody else for it. So your waiver is basically says acknowledge that there is a risk, coronavirus is going on, you could get sick, you could die, whatever the case may be, and that you accept the risk if you show up at the meeting. And you have the right not to show up or the right to show up. And it's basically an assumption. It's called a waiver of liability, but it's also called an assumption of the risk clause. And sometimes waivers are not uphill. That's what lawyers say, that the reason they object to it, but they are frequently uphill if they meet certain requirements. If they're clear and understandable, if they're in a conspicuous place, and in other words, they're not buried, on page 25 of some document, and they're not in 2-point type. They got to be conspicuous, got to be clearly written, and they have to be clearly assented to. In other words, they need to check off a block or uncheck a block, whatever the case may be, that shows that they assent to it. And you'll have a much better defense than if you don't have a waiver in there. The problem is it's going to be real hard to bring those suits anyway, because people go through airports, they go through Uber drivers, all sorts of. How do you know where somebody got sick? Those I think you're going to see cases, and I've seen the cases that have come up already from coronavirus really are in the employment areas. People are blaming their boss for making them show up at work. They're getting sick, and they're blaming their company on it. Restaurants are concerned about it. There is discussion in Congress going on about passing a federal limited liability clause that exonerates every business. They've not agreed to yet, and individual states are discussing this right now, but none of that's been passed. You'll probably see some of that occur in the next 6 months, but it's not out there yet. And in the meantime, I think each individual planner does need to have a waiver or assumption of the risk terms in their registration.
Okay. And I know the topic of this event is about coronavirus, but we've got something else huge happening out there, which is the protests. So this person asked, when can a planner claim civil unrest as force majeure in light of the recent violence during the protests?
Well, and most clauses do say something about civil unrest. And they should, and this emphasizes it. I think if the civil unrest is going on near the venue, I mean, most, if you're meeting at a downtown hotel, or a convention center, and it's going on near and around there, and this is something you perceive is going to materially affect your group, you know, it's worth bringing up. It's no cut and dried answer as to exactly what has to happen, how many protesters that are required. You know, that we're just not there yet. You've got to evaluate the situation, and if it doesn't look like a valid situation that your group wants to be involved in, it may be a matter of changing the dates. I had that situation come up a few years ago when there were riots going on. I'll go ahead and mention this in the city of Baltimore. I was supposed to be a speaker for an event there, and they were going on all around downtown Baltimore. And they called me up. I was supposed to get on the plane the next day and go up there. They called me up and said, "We don't think you want to show up here, and we don't want to go downtown anyway, so we're postponing this event a month." And everybody was in agreement to that. The venue, everybody else. I didn't want to show up in the middle of that. So you got to evaluate the situation. But I think it's a valid claim.
Right, right. I think this is a question from Bethany that I think a lot of companies are probably facing. I have an incentive trip scheduled for January 21, and I know it's too early to cancel with force majeure. However, the company that booked the trip, so she's a third party, is not in the same financial position as it was because of coronavirus. Is there any way to terminate the contract without penalty right now?
That's a very common question. The case law out there has been very clear over the years that economic hardship is not a force majeure, and changes in the unless it's mentioned in the contract. If you mention in there, if you know the economy, and I actually have a clause that deals with that. I mentioned the conference board and their change in the consumer price index and the change in the consumer confidence. But unless you put that in there, you're deemed to, everybody knows the economy goes up, the economy goes down, businesses, you know, lose their financial stability and so forth. And if it's important enough to you, it needs to be in the contract, but you're not going to be able to claim it after the fact.
Okay. Here's another interesting one from Jessica. Almost a challenge, let's say. If you're using very specific situations in your force majeure, does it restrict your ability to use force majeure? In other words, if you get so specific, are you limiting your opportunities?
Well, you are, unless you mention the you know, catch-all phrases that I already alluded to a few minutes ago, is that you need to say including the following events, but not limited to, or you know, or any other act or occurrence that affects the whatever the triggering events are, illegality, commercial impracticability. You need to make sure that those catch-all phrases are in there, because if you just list fire, you know, earthquake, and so forth, then you're going to be limited to those things unless you make it clear that you don't intend to limit it to this, but these are just examples.
Okay. Here's an interesting one. What about, and we've got a couple more minutes left. Let's try to squeeze in a couple more.
All right, I'm ready.
What about facilities that will not let you rebook without paying a cancellation fee, even though the state is only in phase 2? So there's that phase.
Well, it is. I mean, it's more gray areas than there are hard and fast answers right now. I'll be the first to tell you, and it's kind of we're going to have to wait and see. But that's a situation where the parties really need to negotiate with that. And plaintiffs ask me all the time. They say, "Well, you know, I claim, you know, that because of the disease, blah blah blah," and I thought they had a pretty good claim, but they may not get the other side to agree to it. Well, they may not. You may not get the other side to agree to it. That's what dispute resolution is all about.
Right, right.
I mean, sometimes it's a matter of going to an arbitrator or judge or jury if there's enough money at stake. But virtually, you know, most of the disputes, and I really say 99% of the disputes in this industry are settled out of court or negotiated.
Right, sounds like that.
It's just money. I mean, we're talking about money. And so you may have to, if it's a fuzzy area as to whether you've got a good force majeure claim, you know, you may have to pay some damages. Doesn't mean you got to pay the full cancellation that's in the contract, but you may agree to pay some money and then rebook it for a future date or rebook a different meeting for a future date. In order to get contract hotel to renegotiate, you got to give them something they don't already have, which is you got to be able to be willing to come back or book another meeting, unless your excuse is a slam dunk, and that's not always the case, particularly right now.
Okay.
Go ahead.
So this is the perfect follow-up to that, and this is from Nicole. I'm canceling an event and the hotel's agreed to hold my deposit as a credit toward the following year, but the new date has not been determined. What do you recommend I do to document? In other words, how do you just stay safe?
We need a settlement. You need a settlement agreement. You need a side agreement to your contract that says the parties have agreed that, party A will rebook in a date to be determined, that the hotel will hold on to the money in escrow, and that it'll be applied. There are escrow companies out there that I have recommended some of my clients use, that they actually hold the money, but I use that when deposits are required. I recommend that I've written an article that there's no such thing as an unrefundable deposit. If there is a legitimate force majeure or the hotel breaches the agreement, deposits are refundable. And this is what escrow is all about. It allows uninterested third party to hold the money. And there are companies out there in this industry. If you want some information about it, send me an email and I'll point you in their direction. But they're very reputable, and that one of them's called Meeting Escrow, and they will hold your escrow money, and then they have term, until it's been adjudicated that one side or the other is entitled to that deposit, they won't release it. And but you need to document it right. You need to have a separate side agreement on those terms right there.
It's another contract, really. Okay.
Well, it is.
Right.
Yeah, you're right. You're entering another side contract. Exactly.
Right. Right. Well, people are asking you for all kinds of things. So I'm just going to hand all of those remaining questions over to you. I want to, we are at 2 o'clock. I want to thank you so much for taking the hour. We had a full webinar, standing room only, and that's because of you. So thank you for your expertise. We hope to have you back again. I welcome everybody to keep an eye on Prevue's website, because we will be answering hopefully some of these online and even in our print magazine. And so, John, good luck to you. Talk to you again. Have you back, and have a good rest of your day,
all of
everyone.
you for attending. Have a great afternoon. Good luck to you, and thank you, Barbara. Appreciate it.
Thank you. All right. Bye-bye.